Welcome to the Bowman's Kenya Competition Law Podcast. This is a 4-part series which will focus on competition regulation in the East Africa and COMESA regions, culminating in our 12th Annual Africa Competition Conference, which will be held for the first time in Nairobi in February of 2024. Join us as we unpack the current focus of the various competition regulators in the East African and COMESA regions, the impact of the African Continental Free Trade Area Competition Protocol, and what all this means for your business transactions in the region. My name is Joyce Karanja, a partner and head of the competition practice at Bowman's Kenya. To kick us off, I'll be speaking to Francis Wang'ombe about his views on the competition law landscape. As many of you already know, Wang'ombe is the immediate former and first Director General of the Competition Authority of Kenya, which was established in 2013 following enactment of the Competition Act. Wang'ombe is an economist who specializes in industrial organization with 30 years experience in the public service in Kenya. Wang'ombe joined Bowman's in May 2023 as a senior consultant of competition and trade policy, and we're very excited to have him on board. So Wang'ombe, you have been a regulator for quite some time, having left the Competition Authority in January this year. Maybe you can start off by telling us, why is competition law important to our clients?
Thank you, Joyce. Competition law, as you know, regulates contestable markets, where we have many players in the market, or the market can accommodate many players. And in such a market, of course, when our clients want to expand their profitability, their actions and strategies they undertake. One is to increase the market shares. How do you increase the market shares? Through mergers and acquisitions. Two is that you have to have some strategies, either by yourself, through the margins you give to your customers, or you price, whether you may decide to price below a certain level if you have a big market share. The other strategy you may undertake is to collaborate with your competitors in terms of agreeing on quality or quantity or prices. The other angle you take is to attract more customers to your product. That is through advertising or through what you're producing and representing what you're producing. The other area you can increase your market shares also, it may be through how you deal with your suppliers, what kind of contracts you give to them, what kind of terms you give to them. All these strategies, they are under the purview of the competition regulator. One, mergers and acquisitions, you need approval so that you don't create dominance in the market. Number two, your relationship with your competitors. If you agree on a certain market you're going to charge your customers, that's against the law. Or if at all you agree that maybe Joyce, as a competitor, you're going to supply in Nairobi, and Wang'ombe, you're going to supply in Nyeri, that's market allocation, and it is captured as a cartel, territorial allocation. Then also when we come to consumer protection, there's what we call misrepresentation. If you indicate that your product contains these ingredients and it doesn't contain, or you hide that it contains some ingredients which are harmful to the consumer, that also will attract the attention of the competition regulator. And also, if you mislead through advertisement, it will also attract the attention of the competition regulator. There are other provisions like abuse of buyer power. And if at all you can remember, I talked about your relationship with the suppliers, which have been added to competition law in terms of the terms of a contract you give to your suppliers, and also how you change those terms. Were they negotiated? Especially with the small, medium enterprises, competition regulator will be on your radar.
Obviously, failing to comply with competition law could result in sanctions on market players, right?
Definitely. If you offend the law, if you infringe the law, the competition law has very clear remedial measures, which contains fines, penalties of up to 10% of your profits. That's quite high penalties. And also imprisonment, not forget that.
Exactly.
Yeah.
Just moving on, I know you're not a lawyer, and I think one question that comes to mind is, what is an economist doing in a law firm? What do you have to say to that?
I pretend to be a lawyer, but of course I'm not a lawyer.
Yeah.
Joyce, you'll have to agree with me that there's a consensus among the practitioners, among the researchers, that competition law is an economic law. And for any competition enforcement, I have to say the starting block is market definition. And market definition involves economic analysis. And that economic analysis is based on economic framework. I'll not go to the nitty-gritties of the economic framework, but people know about the SNP test. That's an economic framework. That's a test which economists are the ones who apply it. As markets are becoming more and more complicated, especially in the digital economy, platforms, multi-sided markets, I'm seeing law firms outsourcing these services of economists. I think, and I'm aware, Bowmans want to create a one-stop shop for the clients, and that is why one economist, Wang'ombe Karaoke, is in Bowmans.
That's excellent. Thank you. Now, again, just touching on and asking about your experience having been a regulator and now having crossed over. In your view, what's the optimal relationship that should exist between a competition regulator and the regulated? And what role do you see law firms being able to play in that?
For me, is that a regulator should always appreciate the regulated as a person who helps the market achieve what the regulator wants the market to achieve. And therefore, I see it more of a symbiotic journey to that aspirational market are at the point of the market, which is aspirational, I say so. If you are working together, there has to be some predictability on how you need to work together. And this predictability has to be created by the regulator in terms of being transparent in their processes and also giving hope in this journey with the regulated. And how do you give hope? One, as we work together, which is the journey, so there's the strategic plan, the competition agencies, I'm of the opinion they should publicize their processes, they should publicize their earlier decisions, so that at least we can know what is our history and what is the future. And also the competition agencies should create some accountability in terms of what you did to Joyce. Also Wang'ombe should expect that Wang'ombe should expect the same. That is the accountability I'm talking about. Then also is that you'll know this relationship is guided by the law as you have indicated. And obviously is that a law requires kind of dispute resolution mechanism. And also it requires what I may call vertical separation of decisions. The case officer should not be the only person who is determining the end of the journey. There should be the case officer who is recommending to a senior, and that senior is recommending maybe to a director general, and the director general is recommending to a panel of a board which takes that decision. And if at all the regulated, they are not assuaged by that decision of the board, there has to be another agency outside the authority which they can appeal to. Also going back to the processes is that, and this is a constitutional right, the right to be heard. In the essence that if you want to take a decision which is going to affect billions of shillings I've invested in Kenya, give me the platform to come and, ventilate and prosecute my position. Because, Joyce, regulation, it's not about punishing. Regulation, I take that you are trying to solve that problem. You are trying to undertake that journey. And especially when it comes to the new economy, the digital platforms. Let me not lie to you, I was a regulator. We are very much aware of how these markets work. And therefore, also to create optimal decisions, that's why we have to have a collaborative and cooperative approach with the regulated so that we can arrive at that journey we want to move together. And also not to forget to say that as a regulator, you need a lot of flexibility. I indicated that competition law is an economic law. It requires to listen to other voices, public interest issues. It's not a legalistic approach to the law. And any regulator should have the capacity to listen more. And that's why I think our creator gave us 2 ears and 1 mouth to talk.
Okay, thank you. That's very clear. Now, looking forward a little bit, I think, as we know, Kenya is part of EAC, it's part of COMESA. There's this new creature called the African Continental Free Trade Area, which also has a competition element. Maybe I could just ask your views of what the future of competition regulation on the continent looks like, and what challenges do you see these presenting, if any, and what should our clients be doing to prepare for that future?
The future of regulation in Africa will be determined by 2 issues. One, you are aware that there has been transition in leadership of 2 mature competition agencies. A leader is very, very key in terms of determining the future. One is that we have not seen, we have not been able to interrogate the strategic plans of those 2 people who have come on board. We have the South African Competition Commission of South Africa, where my colleague Tembi left and Doris is in charge now. In Kenya, we have where I left and there's someone acting, Adano is acting. So the future depends on them. Then number 2 here, you have highlighted in terms of the future depending on the institutional dispensation. Before we go to the institutional interplay, I think we need to appreciate the institutional architecture and the maturity of the agencies within the region. We have the national competition authorities. In this area, it's only 2 who are operational and functional. That's Kenya and Tanzania. We have others who are operational but not functional. That is Zanzibar. We have Rwanda. We have another one which has a law. It's not operational nor functional. That's Burundi. And then we have Uganda, which has just promulgated a law, but it has not been assented yet. And then we have South Sudan, who are coming up with a law. They have not even drafted one. So that is the architecture at the national competition agencies, which they need to relate with the regional economic communities competition agencies. For clarity, Joyce, is national competition agencies, they deal with competition issues within the geographic boundaries of their states. But with globalization and regional economic communities, is that globalization has erased the geographic boundaries in terms of trade. And therefore, that's why policymakers have seen it key to bring on board regional economic communities competition agencies to deal with cross-border issues. And that is why now I want at this point to turn to regional economic communities competition agencies. We have East African Community. East African Community, they have East African Community Competition Authority, which is operational but not functional. And when I talk about operational, it is dealing with other matters, but it has not started receiving mergers or dealing with cases. Then we have COMESA Competition Commission, very vibrant now. I've seen it expanding its enforcement to full capacity. They were more focused on mergers. Now they have started expanding to consumer protection and also anti-business practices. Now, we have the African Continental Free Trade Area Competition Protocol. I've looked at it. It proposes an African competition authority which shall have the powers to regulate the basic tenets and the traditional tenets of our competition law, that is market structure, concerted practices, and unilateral conduct. And also they have increased the provisions of the law to deal also with the emerging issues in the markets, that is the digital economy and platforms. So you can see these are 3 tier, and they all have some kind of interfacing to be able to actualize their mandate. The continental agency will require the regional blocks, and the regional blocks will require the national competition agencies. So we have the foundation, we have the pillars and the roof. And if one is not functional, it's going to collapse. And as I've highlighted there, it's a house, and a house requires, interfacing in terms of having bars to interface. The iron bars we are talking about is that they need to share information, and they should have the capacity to share information. They need to have the skills, and they need to converge their strategic plan so that we don't have divergent analysis, which will create unpredictability to the business community. And also they have to have robust dispute resolution mechanism. I know all of them now, as we talk about the future, they'll be focusing on food security. It's a priority. They'll be focusing on, matters to do with climate change. Our clients should know that competition agencies always try to align their priorities with the government priorities so that they can get funding from their government. So we should always know that. So let's expect that. The future also, and which is quite daunting, it's how now to domesticate Article 12 of the competition protocol of the ACFTA and bring it to the national competition agencies, taking into account that this is quite a novel provision, not only in Africa, but the whole world. And I know we are going to do a lot of research, but I pray that the regulators will not just transplant what has happened in Europe. They need to balance the innovation part, and also they need to balance the efficiency these platforms have created in this part of Africa and how they have been able to formalize the informal sectors in Africa. And going now, what should lawyers do? One thing is that lawyers are the bridge between the regulated and the regulators. And this bridge should have the capacity to withstand the commotion. And to have that capacity, lawyers need to build skills. And these skills should expand, not just having lawyers in their law firms, bringing in economists, because we are talking about the novel provisions within the new laws, and also having what I may say footprints across the whole of Africa, and not, even if it's not brick and mortar, to have kind of arrangements so that at least they can be able to represent the clients under the African Continental Free Trade Area.
Great, thank you so much. I think that brings us to the end of our conversation. It's good because it sounds like Bowman's is very well placed to provide that service to our clients. We look forward to working together to achieve that goal. Thank you so much for your time.
Thank you, Joyce, for having me.
Thank you for listening to the Bowman's Kenya Competition Law Podcast, and we hope to catch you on our next episode.